At this time, going to introduce an entertainment lawyer who actually went to Loyola many moons ago and then crossed the fence over to Tulane and received... Yeah. He has his MBA from Tulane and a law degree from Tulane and got into the entertainment law business. And Dan's going to be interviewing him. Let's give it up for Dan Friedman.
So before I get started, I wanted to give you a brief rundown on how I got started because it was kind of an interesting story. And I originally thought I was going to be a sports lawyer, and I left Loyola and decided to move to Tulane. Tulane has a good sports law program. And in the middle of my first year over there, which was my second year of law school, I figured that I went to college at the University of Texas. Austin is a huge music scene. Went to law school here, huge music scene in New Orleans, became friends with musicians both in Austin and New Orleans. And I figured, I might as well, start helping out my friends and trying to do work in this field. And it was something that I was actually interested in. So basically, I'm in the middle of my second year of law school. I go into the business school, and there's a guy named John Elstrout there, and he ends up owning a company called Monkey Hill Records, which had Cowboy Mouth, who I ended up doing work for a couple years later. Do you all know who Cowboy Mouth is, obviously? And he also owned a distribution company called Big Easy Distribution. So I'm in my second year of law school at the time, and for the next 2 years, I flew from New York to LA and back on a regular basis, meeting as many people as possible in this business. And I realized that, number one, the entertainment business is like no other. Number two, the entertainment business is completely incestuous. Doesn't matter what your grades are, doesn't matter anything about what your resume looks like. All it matters is who you know. So I end up at a forum, and it was ABA, American Bar Association forum, and I met an entertainment lawyer named Joel Katz, who represents Elton John and Jimmy Buffett and David Allen Coe. And this is third year of the joint program. And Joel says to me, look, you should just do what I did and start in your parents' basement. And I'm like, Joel, it sounds great, but I've got $130,000 in student loan debt, so I don't think that's going to be happening. So do you have a backup plan for me? He said, well, then the next good thing you should do is probably get a job at a big corporate law firm and try to get them to let you do music stuff. So I ended up getting a job there was one big law firm that would let me do music law, and it was a firm back in St. Louis where I'm from. And the firm said, we're going to put you in the mergers and acquisitions department, which basically one company buys another. And at the same time, you could play with your little music thing on the side, and if it happens, it happens. So I start working there, and I'm bringing, this is pre-Nelly at the time, and Nelly and Chingy and that whole crew is from St. Louis. So I start bringing rap producers in the office, and bands in the office, and some jam bands in the office. And the partners, it's a pretty white bread, conservative, stuffy law firm, wear suits every day. And the partners started to come into my office after about 6 months a year and said, we really don't like these people in the office. And I said, what do you mean? I'm one of the few associates at this office that actually is bringing clients in. And they said, well, just try to keep them, on the side. We represent some Fortune 100 companies, and it really kind of cheapens the office when these people are actually here. So I kind of ignore it and keep doing what I'm doing. And after about 2 years, I'm starting to develop some more and more clients and bring clients in the office on a regular basis. So I have a jam band in the office, a band out of Ohio at the time called Acoustic Hookah. You may or may not know them. Similar to like the Dead and Fish, but on a little bit lesser level. And they were doing what jam bands do, and they walked in the office and they were from sober. And the partners in the office called me into their office in the conference room after a 3-hour meeting that I had with the band, and they said, Dan, we need to have a meeting. And I said, what do we need to talk about? Well, you need to drop your clients. And I said, I'm not dropping my clients. What are you talking about? I've been doing this for 2 years, and we made a deal. The only reason I'm back in St. Louis is because is because you told me you were gonna, let me do what I wanted to do, which is develop an entertainment practice. And they said, you need to drop your clients or you need to leave. I said, I need to talk to the managing partner. And at law firms, there's one guy in charge of everything, and there's 250 lawyers here. So the managing partner comes down and says, Dan, I know we made a deal. We're going back on our word. You need to drop your clients. I said, you're telling me to drop them? I said, why? And he said, well, we didn't really know what we were getting ourselves into. And I said, what? Did you think I was going to bring Neil Diamond in? And they were like, something different than what you're actually doing. So I said, so you're telling me to drop my clients? They said, yeah. There was dead silence in the room for like 4 minutes, and I said, I guess I'm out of here. I walked to my office, packed up my stuff. February of '98 until now, I've been on my own, basically building up my practice, and it's gone pretty well up to this point. So that is pretty much my story, and that's how I got to where I am today. So any brief questions before we get to substance? Okay, so today I'm going to go over a little bit of like the gist of copyright law, but only how copyright law really affects music. And then I'm going to get into a little bit about recording agreements and go over like main points of recording agreements. And then Dan Helfers is going to come over and he has a bunch of questions he's going to ask. And then we'll open it up to some general questions. So copyright law as it affects music. And you all have handouts, correct? Okay, I'm going to reference that as we're going through this, so just keep it out. So have any of you taken any brief copyright classes at all? Raise your hand so I know like what we're talking. So some of you yes, some of you no. Okay. So if you know some of this stuff, great. I may be asking you questions. We can go from there. So the basics that I'm going to go over some basic issues on, again, Title 17 of the U.S. Code, which is the Copyright Act of 1976, talk about some fair use and defenses to why people can use other people's copyrights, what happens when somebody infringes people's copyrights. Then we're going to go over a recording agreement and then Q&A. So first question is, what is copyrightable? And what is copyrightable is a work of authorship that has to be original and of sufficient materiality to constitute a work. The question is, what is original? Original is something that's not copied and minimally creative. That is probably the best way to describe what actual originality is. However, there's been many court cases to determine what actually original means. Materiality, there's no test to cover this. However, the perfect example is the 5 notes played by the spaceship in Close Encounters of the Third Kind. That is copyrightable because of their originality, even though they're just 5 notes. The rule that copyright doesn't protect ideas is called the idea-expression dichotomy. And basically, there's public policy in the United States, which is embodied in the Copyright Act, that says that ideas, as opposed to the expression, is not copyrightable. There's several classes of copyrightable works. Let's go there. The first is literary works, like books and films. The second, which we're going to get to in a second, is musical works, which is a musical work and a sound recording is what we're basically going to talk about in a recording agreement, which we're going to get to. The other type of copyrightable works are dramatic works, which are like stage plays and screenplays. Then we've got pictorial, graphic, and sculptural works, which is 2- or 3-dimensional works of art. Motion pictures and other audiovisual works, and pantomimes and choreographic works are all pretty much self-explanatory, and architectural works, which are like basically designs of a building. Does anybody know the difference between a musical work and a sound recording? You've taken music business classes, right? Okay. What's a musical work? Anybody have any answers? Well, it gets into a little bit more detail. A musical work, yes, is an underlying musical composition, and and a sound recording is the version of the song, but yes. Yeah, that's actually a good way of describing it. I have an example, and there is what people call the real estate of the music business is the copyright to the musical work, which if you look on a CD, there's a copyright, there's a C with a circle and a P with a circle. The C with the circle is the copyright to the underlying work. The P with the circle is the copyright to the underlying musical composition, to the version of the work. There's a song that Bob Dylan wrote called Knockin' on Heaven's Door. It's been covered by everybody under the sun, including Guns N' Roses, Eric Clapton, Babyface, Roger Waters. The best way to describe the difference between the underlying musical composition and the sound recording is the sound recording for the covers. Like when Guns N' Roses covered Knockin' on Heaven's Door, the sound recording is owned either by Guns N' Roses or the record company that Guns N' Roses is signed to. The underlying musical composition, which is the real estate of this business, is owned by Bob Dylan. It'll always be owned by Bob Dylan until Bob Dylan does what's called a co-publishing deal with a third-party publisher, or he doesn't do a deal at all and continues to own the publishing himself. So again, just so you know, you remember this because we're going to get into this when we talk about record contracts, the underlying musical composition doesn't get assigned to the record company. It stays with the artist or gets assigned to a publisher. The sound recording gets assigned to the record company or stays with the band if they don't have a record deal. And this goes over basically what we talked about 2 seconds ago. Once you have a copyright, there are several exclusive rights that the copyright holder has. First of all, the copyright holder has the right to reproduce the work. No one can record the work, publish the work, or put it in a movie without the copyright holder's permission. Nobody can distribute copies of the work or distribute copies of the work, like selling CDs to the public. Nobody can perform the work publicly without your permission. However, there's a little asterisk here because this would be very difficult to police. If I wrote a song and I want to go license that song to radio stations and nightclubs and other types of venues, it would be very difficult for me as a songwriter to go do deals with all of these songs. So that's how a performing rights society was created. And what they do is issue blanket licenses to bars and venues and radio stations. And they collect the money and then pay money based on a mathematical algorithm based on the amount of times a song is played either on the radio or in a bar or in a music venue. And that gets paid to the songwriter on a quarterly basis. The songwriter also has the right, and the copyright holder also has the right to make derivative works. That's a creation based on another work, and there's 2 examples here. One is, do you all know Weird Al Yankovic? Okay. The prime derivative work is him making a song based on another song that's previously copyrightable. Now, there's an exception to why that's allowed, and it's called a parody, and that's fair use, but it's still a derivative work nonetheless, and there are exceptions to these, which we're going to get to in a second. The second type of derivative work is what's called a sample, which is primarily in rap, where a rap artist will take a piece of another song, stick it into his song, and then it'll be released on a major record label. When that happens, you have to get the sample cleared. If you don't get the sample cleared, you end up in a copyright infringement lawsuit, which I've been involved in several of them, and they're definitely not fun. So it basically is what it is. And the last exclusive right is the right of public display, which really doesn't affect the music industry. Okay, so the exceptions to exclusive rights, which we just talked about. basically, the Copyright Act requires the copyright holder to issue licenses for cable TV rebroadcast, for PBS, for music playing on PBS, and for music playing on jukeboxes. For some reason, the lobbyists at the time the Copyright Act was made allowed for the licenses for those three to be cheaper than other types of licenses, which we're going to get into in a second. The other types of exceptions to exclusive rights are the next two occurred in the 90s, the digital performance of records and the digital distribution of records. And the key, the most important of which is phonorecords of non-dramatic musical works. That's basically a dramatic musical work is a musical work created as part of an opera or play, and a non-dramatic musical work is mostly music. So if somebody is covering a song, like what we were talking about with Bob Dylan and Knocking on Heaven's Door, Bob Dylan doesn't have the right to say, no, you can't go record that song. The person has the right to record the song. It's set forth in the Copyright Act of 1976, and the reason why they have that right is what's called a compulsory mechanical license. Now, the compulsory mechanical license and a regular mechanical license, the mechanical license is the license that the songwriter allows the person to record the underlying composition. Those licenses are usually issued by the Harry Fox Agency, and you could do it pretty much online. Okay, mechanical royalties are paid to copyright owners for the manufacture and distribution of records, and currently mechanical royalties, according to the Copyright Act, it usually changes once every 2 years. However, this year was the first time that it actually stayed the same for the previous two. So for 4 years, the mechanical royalty rate is 9.1 cents per CD or digital download sold on the internet. Okay, so again, we're talking about compulsory mechanical licenses. These are required by the copyright owner if all of the following exists. The song must be a non-dramatic musical work. It has to have been previously recorded. If I write a song and don't release it to the public on a record, then nobody has the right to record that song until I allow that issuance. I could either allow the issuance by recording it myself and releasing it, or somebody can pay me a separate fee outside of the compulsory mechanical license fee in order to, if somebody really wants that song. And a lot of songwriters hold on to songs and then get paid extra money in addition to the mechanical licenses for that right of first use. In addition, the previous recording has been distributed publicly in phonorecords, and your recording doesn't change the basic melody or fundamental character of the song. Again, you have the rap issue here, specifically with sampling. If somebody is sampling a song, again, the owner does not have to issue a compulsory mechanical license. There has to be a separate negotiation, and the underlying copyright holder, the person who's being sampled, can absolutely say no and prohibit the sample from being in the song. If the sample is already on a song and released by a major record company, they could stop the song from being released and actually pull all the records out of the marketplace. The duration of copyright, general rule of thumb is life of the author plus 70 years. It gets a little complicated. We don't need to get into the technicalities because it's really not relevant here. But if you're interested, I could send this over and you could read it at some point later. Okay, who owns the copyrights? Always, the owner, the author, or the artist owns the copyright unless there's a written transfer of ownership. Let's pull out the record contract that I passed out and go to page 2, paragraph 2. again, we need to differentiate between the two types of copyrights. The sound recording copyright is the copyright that's always assigned to the record company. And if you read the first line of that paragraph, it says, each master recording hereunder and all reproductions derived therefrom shall be company's property and shall be the sole copyright proprietor thereof, which basically means the company at this point, when an artist signs a record contract, is going to be the owner of the copyright to the master recording, but will not be the owner of the underlying composition. The owner of the underlying composition stays with the author. Okay, the other issue dealing with ownership in music is joint works. A lot of times in music, you have people collaborating on music, and a lot of you all are musicians, right? Okay, so if you collaborate with somebody on a song and you intend for that song to be one work, then it tends to be a joint work. And unless you agree otherwise, the two people that are writing a song together or the three people that are writing the song together are going to own it equally. So there needs to be an agreement to the contrary unless, and if there's no agreement to the contrary, then it's equal amongst the people that write. There's general rules of thumb with regard to how copyrights are split. First of all, there's no exact science here, and a lot of lawyers and managers have different thoughts on this. But generally, the lyrics are 50% of the song, and the music is 50% of the song. Now, we've moved from the sound recording copyright. We're now talking to the underlying music about the copyright to the underlying musical composition. When you go to Nashville and people are co-writing, if there's 3 or 4 or 5 or 6 people in a room all writing, those people are going to split everything evenly. If one person did nothing, that person is still going to get a piece of the action in that song because that was the rule, and that's what they usually agreed in prior to actually writing. With rap and R&B, the producer actually writes the music with the intention of lyrics being put on the song at some point in the future. So one of my jobs as an entertainment lawyer is I represent a bunch of rap producers. I take those rap producers, they give me 10 tracks or 20 tracks a month, and I end up shopping them to major labels in New York, LA, Nashville, Atlanta, and I give them CDs with just music on them. The A&R people at the labels will take them, they distribute them to the rappers who they think they'll like them, and those rappers will write lyrics. When the rappers write lyrics to a song and all parties agree, then each party, let's say there's one rapper that writes lyrics to a Jermaine Dupri song. Jermaine Dupri is going to own 50% of the song, and let's say T.I. is going to own 50% of the song. Each will own an undivided interest in that 50%, even though J.D. wrote 50% and T.I. wrote the 50% of the lyrics. With regard to bands, I have some bands where the songwriter keeps 100% of the ownership of the underlying composition. I have some bands where everybody splits everything evenly. Again, as a lawyer, I represent a band. I have an obligation to the band as a whole. I explain to them the options. The problem if the songwriter keeps the ownership of the song and the band blows up, the songwriter is going to end up becoming a multimillionaire off of the songs, and the rest of the band is not going to make that much money because one of the 4 streams of income that a band makes is from publishing. So as a lawyer, or if you all are going to be future managers on some level, it's important to explain this to a band because there's different theories. One is that the songwriter wrote the song, so he should make everything. On the flip side, without the band, there would be no way to exploit the song. So if you buy that line of thinking, then the band should split everything equally. There's a hybrid of the two as well. I have some bands that the songwriter gets a little little bit extra than everybody else. But if you're representing a band and you want the band to go on as a going concern for a long time without a lot of conflict, the best way of moving forward would be some type of splitting arrangement between the band members. Okay, again, in the music industry, once you're a co-writer of the song, you probably want to enter into one or two types of agreements. If you're a co-writer, you have the right under the Copyright Act to license that song to whoever you want. But you also have an obligation, if you wrote it with two other people, you can go license that song to MTV, but you have to split the money that comes from that song with the two other co-writers. And that would be a copyright split agreement where you're splitting the song, where everybody can go license to whoever they want. The other type of agreement would be a co-administration agreement, which is what I actually prefer, where everybody who owns a piece of a copyright has the right to go do a deal for themselves. So if let's say the House I'm in the middle of doing a deal with House on Fox, and I have a couple people that wrote a song that is going to be on that TV show. So both parties have the right to do two separate deals for their undivided interest in that song. Does that make sense? Yes, good. We already briefly talked about the formalities. Again, the copyright notice for the underlying composition is the C with the circle. Copyright notice for the sound recording is the P with the circle. With regard to registration, registration is not necessary in order for a copyright to be a copyright. A copyright is a copyright when it's fixed in some kind of tangible medium, but you do get extra benefits if you register a song. The registration is voluntary. Registration before infringement provides for better remedies. The cost is, I think, $45 a form, so it's cheap, and the procedure is easy. You go to copyright.gov and follow the instructions, which are extremely user-friendly. If you don't register, you cannot collect compulsory license royalties, which we've already talked about. You can't file an infringement action. If you don't register within 5 years after first publication, you lose the legal presumption that everything in the registration is valid, and you can't collect attorney's fees. So I have a little example from a previous lawsuit that I've been involved in. Do you all know the group the Nappy Roots? Okay, I have a client that wrote the music to the song Po Folks, which was on the album Watermelon, Chicken, and Grits. Do you all know the song? Okay, so my producer, his name's Willie Woods, he called me up about, I think it was 4 or 5 years ago, and says, hey, Dan, I wrote a song. It's going to be on this group called the Nappy Roots, which is out of Kentucky. And I'm like, great, what's the deal? And he said, well, they're supposed to be providing the paper. And this guy doesn't know anything from anything with regard to copyright law. He was in somebody's basement, and he was recording the guitar. That song is guitar-driven. So he wrote the guitar parts. He wrote the bass parts. He laid it all down, and we were expecting paper. Well, the record comes out, and we don't have any paper, and Willie calls me up, and he's like, well, where's the paper? I'm like, I don't know. You told me that the Nappy Roots lawyer was supposed to get a hold of me. So Nappy Roots lawyer never calls. 6 months go by. They've sold over 1 million copies of the album, and my boy is getting a little infuriated because everybody else is driving their Escalades, and he's still driving nothing and living in his mother's house. So I end up calling the Nappy Roots lawyer. The Nappy Roots lawyer says, hey, Dan, we'll give you $5,000 to go away. And I said, Jess, you're out of your mind. The mechanical royalties alone are worth over $100,000 at this point. So he hangs up the phone on me. I call him back up. I said, I think we got disconnected. He said, no, we didn't get disconnected. You need to file a lawsuit if you're going to chase this down. So he slams the phone down. We file a lawsuit. 2 years later, we settle. My guy ends up with more money than he would have gotten if they would have done it the right way. He got his platinum plaque, and he's doing okay for himself at this point. So pretty much the deal. So at this point, I want to go over the basic terms of a record contract. And I want to reference page 5 of, I think you all have one handout, so we're going to be going back and forth for a bit. There's page 5 of 7. It says recording agreements, deal points, and then the actual recording agreement. Are we close? Okay. 5 minutes, we'll go over this. Okay. So basically, there's major labels, which you all know about. There's independent labels, which you all know about. The money is substantially different between the two. And there's also what's called upstream deals, which is what this is. Major labels, at some point within the past 5 years, figured out that they don't have the infrastructure or the resources or the ability to break a band and get a band up to like 0 to 50,000 units. They have the ability to take a band from 50,000 to 2 million units because most of the time they're focusing on radio. And radio sells records primarily, pop radio or top 40 radio sells records. So, what several of the major record companies did was actually create the minor leagues, which is the upstream labels. So they're basically funding independent labels, and in the independent label agreement that the artist is signing with the label, there's what's called an upstream provision, and the upstream provision basically says that at any time during the term of the independent record deal, the major label that they're associated with can pull the band from the independent label to the major label for a pre-negotiated deal. The pre-negotiated deal in this agreement is on page 6, and it's 11B through 12. Now back to, I want to cover one more point before we get to questions, and then if you all have further questions, we can get into it. But we were talking about the sound recording copyrights, and the sound recording copyrights, again, are transferred under paragraph 2 on page 2, and in exchange for the sound recording copyrights, the artist gets a royalty, which is set forth in paragraph 5. The general artist royalty for a baby artist for both a major and an independent label is anywhere between 12 and 16% of suggested retail. Everybody pays suggested retail on the major level except for Sony BMG, which pays on a wholesale basis, and now EMI, which pays price per dealer, which is wholesale price. So the royalty rate is generally the same money-wise as far as pennies are concerned, regardless of what major label you're talking about. The other issue I want to talk about is, or the other item I want to point out is on page 4, mechanical royalties, which is on paragraph 6 on page 4. And this is called the compulsory license provision. For a recording artist who's actually writing songs, they're not only going to get the record royalty, they're also going to get a mechanical royalty. Again, the mechanical royalty is the royalty that's set out in the Copyright Act. It's 9 cents per song per CD sold. If a recording artist signs a deal with a major label, then they're also generally going to agree to take a lesser mechanical royalty than what's set out in the Act. And the general rule of thumb for a baby artist, at least what the labels try to get you to agree to, is 75% of that 9 cents times 10, because most albums are going to have a minimum of 10 tracks on them. So everything over any tracks that an artist wants to put on a CD over that 10 is generally going to be free unless you can negotiate a higher cap for the payout. So you're going to, and in addition to the record royalty, you're also going to see, as an artist, an additional 70 to 90 cents per CD sold or per album downloaded on the internet. Any questions on copyrights and copyrights dealing with record contracts? No, let's go.
Hear me? Anybody? No? Hear me now? Yep. All right. I met Dan a couple years ago through a mutual friend of ours who is working at a. Thanks. I met Dan a couple years ago through a mutual friend who's working booking concerts in San Diego now, and just the past couple of years I got to know him pretty well. Just any questions I had for music industry, and he's basically the guy to ask. So I have a couple questions for Dan. A lot of it dealing with just what kids like us are dealing with. First one is, what should artists be doing? When should they be looking for representation from labels, from booking agents, from lawyers? Where should they look first?
I get these calls all the time, and some are at different levels of development. So I would always say that an artist should be doing as much as they can on their own before they find really anybody. And I also would tell them not to sign anything without having a lawyer beforehand. I have way too many. I'm in the middle of 3 lawsuits right now trying to get artists out of record deals that they've signed without having a lawyer or having a lawyer that didn't know what they were talking about. I have one that used a divorce lawyer. Most divorce lawyers don't know anything about intellectual property law or the music industry for that matter. So back to your question, I would definitely recommend, I always have to respect bands that are doing a lot of stuff on their own, whether that's internet promotion, building up a nice touring base either locally or regionally, or creating some other kind of marketing on their own level before they, to try to establish some kind of a fan base.
Speaking of marketing, what are some of the best things that you see bands doing to market themselves independently?
I have a band called Making April actually, and they got a deal on Universal because they were doing a lot of stuff online, specifically on MySpace, and I met them when they were selling about 1,000 singles a week. They're 20, 21, 22-year-old kids, selling 1,000 singles a week, 200 albums a week on their own. That's real money that they were splitting 3 ways. And they called me up and they're like, we need a record deal. I'm like, what's going on? How are you doing this? And they all had, they had a war room in one of their parents' basements. They were blogging and adding friends on MySpace and doing other types of marketing type stuff, basically working 24 man-hours a day. Before I met them, it was for 6 months. And after I met them, I saw checks where they were making $10,000 to $15,000 a month each, and this is before they even toured. From this, they ended up getting on tour with Secondhand Serenade, got a deal with Universal Records, and they're now in the studio recording an album. So, again, the more you do on your own, the more leverage you're going to have to go get a deal, or at least give me the tools to go get a deal, or a manager to go get a deal for you.
Now, once you decide to start working with a band, for whatever reasons they're working their butts off, what do you ask from the band members once you are representing them?
If I'm going to invest my time and energy in working with the band, with baby bands, I work on a percentage, just like a sports agent would work. So if I'm going to spend my time where I could be charging hourly to do other types of work for a band, I expect them to work at least as hard as I am. Because this is their business, this is not my business. I'm just joining as part of a team. So, and I'm usually the first or second person into that team besides the band themselves. So it's important for me to develop a good relationship with them, a good working relationship with them. And, and at that point, decisions are made collectively between me, the manager, possibly the agent, and the band.
Speaking of bands working for themselves, obviously bands, a lot of songwriters and things like that are being touring, making money off that. How do you deal with producers as opposed to artists who aren't touring? How can producers make enough money without touring at all?
Okay, well, there's small producers and more established producers. The producers generally make, on an independent record deal, you have what's called an all-in recording fund, of anywhere between $15,000 and $50,000. On a major record deal, you've got, at this point for a baby artist, an all-in recording fund of $125 to $250. The producer is going to end up making a fee for making the record, which is an advance against future royalties. So they make their advance on an independent record. They'll make, on an independent record on like Fueled by Ramen or Triple Crown or Hopeless or Fearless, one of those labels, they'll end up making on the low end around $20,000 to $25,000. That's an advance against royalties. A standard producer royalty rate is usually 3 points. So if an artist is making 15 points, they're giving 3 of those points to the producer, and the producer is actually making money at the same time. There's been a recent trend, but I haven't seen it really in practice yet, where people are talking about including the producer, since they're really integral in making the record that an artist is going to tour on, to include the producer in a piece of revenue for merchandise and touring and publishing. However, I haven't seen that in practice yet, although I probably will see it, at least for more established producers, sooner than later.
Just to clarify real fast, were you saying that the deal would include producers getting a cut of the touring?
That's what they're talking about. I haven't seen it yet.
Okay.
Yeah.
And I guess that artists would probably be pretty against that.
Correct.
Okay. A little bit about students. I know there's a lot of people in here that don't know exactly what they want to do outside of just something in the music industry. You got into doing the entertainment law, not wanting to get into music in the first place. Can you give some advice to kids getting out here who don't exactly know what they want to do? A little bit about the ways you can start out.
Yeah, I get these calls all the time too. I would recommend if you want to be in music but don't know what you want to do, I would try to learn as much as possible and talk to as many people as possible, both as far as agents are concerned, as far as managers are concerned, as far as publishers are concerned. There's a lot of different roles at record companies. There's the A&R department. There's the marketing department. There's the radio department. There's accounting, which is kind of bland. But there's so many different things that you could do in the music industry. You gotta try. I would explore and see what interests you, and have a passion about something, and then meet as many people in that area as possible. That's the best way to try to focus on what you'll end up doing. But the more experience, if you work for free, you can at least, or volunteer to work for free, you can usually get yourself into a job where you can figure out whether that's something you're interested or not interested in.
I know we'll probably open up for questions in a second. I guess one more question. Can you talk a little bit about, aside from negotiating contracts, just the nitty-gritty details of it, can you talk a little bit about the timeline, how you get involved with labels, what's the process until the deal's done?
Every band is different. So if a band's live show is great, well, first the band and I have to decide on what direction we want to go. If a band has a song that is ready to go to radio right now, then the band needs to understand that most major labels are going to take a song to radio. If it goes, and it's great. If it doesn't go, the band is over, and the band has to redevelop themselves. So basically, if you're a really young band, it's not the worst thing in the world to go, sign to an independent record label. If you sign, on the flip side, if you sign to an independent record label, but you have a song that can go to radio, the independent record labels don't have the resources, the funding, or the radio relationships to actually go to radio and take a song to radio. So you're going to lose that song, and that's really what happened with the Plain White T's when they were first signed to Fearless, because Hey There Delilah was on one of the first albums, and then later put on the Hollywood Records release several years later. That's an exception to the rule, though.
Well, great. Anybody have any questions for Dan? I'll stick a microphone up here, I guess.
Hi. Is it possible to make a decent living, to have like an entertainment law practice in a place like New Orleans, or do you pretty much have to go to a place with a bigger market to make anything?
That's a good question. Actually, when I first started, everybody told me you have to be in New York, LA, or Nashville. And I started in St. Louis. There was nobody doing what I was doing there. I got lucky because Nelly kind of popped at that point, and I was on one side of most of those deals. Same thing with Chingy, same thing with Jaquan and some other rappers in that area. And I ended up doing a lot of work out of Chicago, St. Louis, Kansas City, Omaha, and Memphis, while also developing clients all over the country. So yes, you can make a really good living. And being in New Orleans, and there's also music here, you can't focus specifically on New Orleans, but it's a good place to start and develop relationships. Remember, you have to have those relationships with the artists, and then from there it grows. Any other questions? We're good. All right, no problem.